Welcome, everyone. My name is Harold Trinkunis. I'm the Deputy Director of the Center for International Security and Cooperation at Stanford University. Welcome to our weekly research seminar. It's a great privilege to have Professor Tanisha Fazal of the Department of Political Science at the University of Minnesota join us here today. She works on sovereignty, international law, and armed conflict. She has two fantastic books, the first one on state death, the politics of geography of conquest, occupation, and annexation. And her most recent book, Wars of Law, Unintended Consequences in the Regulation of Armed Conflict. We're very much looking forward to the conversation today about her work entitled Islamic Humanitarian Law and Islamic Armed Groups. Thank you very much, Professor Fazal, for joining us.
Thank you, Harold, for that kind introduction. It is always a delight to be able to present to a CSAC audience. CSAC, I think, was really probably my first intellectual home, and I'm just sorry that I can't be there with you in person. I'm going to start today by telling you a little bit the origin story of this project. I've been working on international humanitarian law for a number of years now, and one of the first papers that I published out of this project was a paper with a graduate student of mine, Brooke Green, where we wanted to respond to this literature on international humanitarian law, which is, of course, the body of international law that governs how belligerents treat each other during an armed conflict, as opposed to the body of the laws of war that governs when you can actually enter into conflict. But in any case, what Brooke Green and I wanted to look at in this paper was whether identity mattered in civilian targeting, because there was a lot of literature out there that was discounting this notion that states in their wars with each other might be more or less likely to target each other's civilians depending on differences in identity. But the way that this literature was treating identity, we thought was not as thoughtful as it could be. And we had both been doing a lot of reading on the history of international humanitarian law. And one of the things that really struck us was how Western and Judeo-Christian this history is. And so we hypothesized that European states might treat non-European states differently. In other words, that was the salient identity. And so that was one of the findings of this paper. Since then, I've been doing a lot of work on international humanitarian law in the context of civil wars. So in another paper that came out last year with a former graduate student, Rita Kanayev, who's now at Georgetown, we looked at this really interesting non-governmental organization called Geneva Call. And one of the things that Geneva Call has done, really what it's known for, is to create this platform that rebel groups, or in the language of international law, armed non-state actors, can sign on to publicly commit to international law, because they can't actually be signatories to international laws or conventions like the Geneva Conventions. And we wanted to understand why it was that some rebel groups signed on to these platforms and to this platform and not others. I've also done a fair amount of work linking the political aims of rebel groups to their military strategy. And so here I've focused a lot on secessionist groups, like the Kurds, who I argue have particular incentives to send signals that they would be good and capable members of the international community if they were let into that community. And so they do tend to act, I think, more restrained when it comes to issues like civilian targeting than groups with other kinds of political aims. And then I'm in another paper with another graduate student, Minju Kwan, who's at Chapman University. We're looking at a different non-governmental organization here, the International Committee of the Red Cross, which is, of course, the sort of self-appointed monitor of international humanitarian law, the guardian of international humanitarian law. And one of the reasons that the ICRC has been so successful, especially in gaining access to conflict sites, is that it has almost always relied on this principle of discretion. If you let us in, we're not going to tell the world what we see. But in recent years, the ICRC has increasingly been breaking discretion. They've been going public. And so we're trying to figure out why they go public in some cases and not others, and why we have this trend. But really the main product out of this research stream is one that Harold mentioned, which was my 2018 book, where I look at the history of international humanitarian lawmaking and how it is that as the laws of war have developed over time, increased in number, but also changed in character, how belligerents in interstate wars, so here states fighting each other, have responded to changes in international humanitarian law, and also how rebel groups and states fighting civil wars have responded to these changes as well in these kind of different domains. And one of the findings from this book is that who's in the room matters greatly when these laws are being made. And so when we look at who's in the room when international humanitarian law has been made, we find that it's states. I mean, it's mostly white men, especially historically, but it's also states. Because states are the signatories to international humanitarian law, to international law in general. And while sometimes non-state actors are let into the room, they're not able to really weigh in a consequential way, at least certainly not compared to state participation in this kind of lawmaking. And one of the consequences of that is that most of international humanitarian law really has been about kind of state-on-state warfare. And in fact, this is somewhat strategic because states don't necessarily want to put any constraints on themselves when it comes to dealing with challenges from below, dealing with rebel groups or armed non-state actors, because they don't want to accord any legitimacy to these actors. And then another feature of the history of the lawmakers when it comes to IHL is that these are mostly Western states. Now, it is the case that some other states, for example, Muslim majority states, have participated in international humanitarian lawmaking over time. But I think one of the really striking features of their participation is that it is often accompanied by the attachment of reservations that frequently invoke Islamic law. So we have these lawmakers, states, and mostly Western states, but then the law takers, the actors that are supposed to comply with international humanitarian law. And what I argue in the book, and part of the impetus for this paper also, is that there's really oftentimes a gap between the lawmakers and the law takers. And one of the reasons that we see this as a problem here is, of course, that even though much of international humanitarian law really focuses on interstate warfare, most wars today, as this audience knows very well, are civil wars. And also many of these civil wars, if not most, are occurring in Muslim majority states. Now, this in some ways connects the geographic concentration of civil wars today connects, I think, with a conventional wisdom that Islamic armed groups are especially badly behaved when it comes to the issues that are covered by international humanitarian law. And while there was, I think, a fair amount of research on civil war onset in Muslim majority countries a number of years ago, this research really subsequently hasn't focused as much on the relationship among religion, law, and the conduct of war. And so putting all this together, given that most wars today are civil wars occurring oftentimes in Muslim majority states, but that the governing international humanitarian legal regime has these Western roots, we wanted to try and figure out whether there's an alternative legal code that Islamic armed groups might be adhering to. And so to answer this broad question and to preview some answers, we wanted to know, is there such a thing as Islamic humanitarian law? We think there is. We also wanted to know whether there are differences between Islamic humanitarian law and what I'm going to call public or Western humanitarian law. So what we might think of as, the part of humanitarian law that has the Geneva Conventions as key to it. And here we think that, yes, there are some differences, but actually, for the most part, these two bodies of law overlap substantively. Do Islamic armed groups make rhetorical commitments to Islamic law? And here our answer is yes, we think they do. And then finally, and this is really the question that we care about, do Islamic armed groups behave differently from non-Islamic armed groups when it comes to humanitarian law? And here we're not so sure. We actually think that there's certainly no clear evidence that they do in a systematic way. So before I go on and give you the legal analysis and also the results of the empirical analysis, I want to talk a little bit about Islamic law. And I should mention that my co-author and colleague, Amelia Powell, is really the expert on Islamic law here. So Islamic law is very different from public international law. When we talk about international law, oftentimes we talk about the sources of law. And as opposed to being sourced in treaties and judicial opinions, really the main source of Islamic law is the Quran. And of course, the Quran was written a very long time ago. And so this means that modern Islamic law is really based on interpretation by legal scholars, legal writings. And there are, of course, multiple schools within Islamic law. And Islamic law actually doesn't say too much about humanitarian issues, the laws of war, or jus in bello. When we hear Islamic law being invoked in the context of armed conflict today, it is often sort of side by side with discussions of extremist groups. So you hear reference, for example, to the verses of the sword. And we want to, in this paper, point out that the view of Islamic law that we are going to be presenting is really consistent with the 2004 Amman message, which is the closest thing that the Islamic legal tradition has to a consensus statement on the content of Islamic law. And in fact, the Amman message is a response to extremist groups. Now, in part because Islamic law is so diverse, there has been this opening for more fundamentalist strains that hew to a more originalist interpretation of the Quran in the same way that fundamentalist Christians hew to an original or literal interpretation of the Bible. But these interpretations are largely viewed as being far from the core or really the mainstream of Islamic law today. And I'll return to these extremist groups later, but I just wanted to be clear that we're trying to present what we see as a more mainstream view of Islamic law. So let me then present kind of a snapshot of our legal analysis. So we are looking at a few different issue areas within humanitarian law. And what we find in the legal analysis is that there's really not much difference when it comes to the civilian targeting and treatment of prisoners of war. Neither civilian targeting nor maltreatment of prisoners of war is permitted in the Islamic or the Western or public international humanitarian law tradition. So there's not much daylight on those two issues. Both traditions also prohibit child soldiering, but of course, the age of adulthood is different. For public international law, the age of adulthood it starts at age 18. And this is true, of course, not just for humanitarian law, but also for human rights law. In Islamic law, childhood ends at the onset of puberty, often taken to be around the age of 15. So you could imagine that you might have somebody in an armed group who's 16 years old who, under Islamic law, this might be permissible because they're not considered a child soldier, but under public international humanitarian law, this would be considered a violation. And then the other issue that I want to mention, the other issue area, was one that we weren't really looking for in the legal analysis, but sort of stumbled upon, and that's treatment of the natural environment in war. And what we found was that while there's a little bit on this topic in public international humanitarian law, there is actually seems to be more of a consistent commitment to protect the natural environment in war in Islamic law. All right, so that is, again, in a nutshell, our legal analysis. And I want to move on now to what it is that Islamic armed groups say their relationship is with Islamic humanitarian law. And so this is a screenshot of a code of conduct from the Moro Islamic Liberation Front. And it's, you know, it's in English here. It was distributed by the ICRC. And it references Islamic texts and Islamic values. And it says that, you know, civilians and prisoners of war should be protected and treated well, that child soldiering is not permitted. And there is, a pretty clear rhetorical commitment here to Islamic humanitarian law. More generally, we looked at a number of these kinds of documents, about 100 documents from different Islamic armed groups. And what we found was that these groups at least seem to pay lip service to Islamic humanitarian law, and in a way that conforms with our legal analysis. So it kind of lines up with our prediction. And I think that one of the most interesting things about what these groups say about Islamic humanitarian law is that they often contrast it with public or Western humanitarian law, but the contrast is not in terms of content, that they see, substantively that there are differences in what these two legal codes would let you do, but in terms of pedigree or tradition. And so there is this sense of pride in Islamic humanitarian law, that it's been around for a really long time, and that the West was kind of late to the party with their 1949 Geneva Conventions. So that is what these groups say, but really what we care about is what they do. So we ran, I'm going to present results from a series of statistical analyses, but of course, in order to conduct these analyses, we needed a list of Islamic armed groups. And we use Gledish and Rudolphson's list of Islamic armed groups here, and they define Islamic groups as, quote, those groups that adhere to a religious ideology with the overall goal to strengthen Islam nationally or globally, and who are willing and able to use violent means to attain this end. As this doesn't work perfectly, but as a rule of thumb, a lot of the groups that have some variation of the word Islam in them get coded as Islamic armed groups. And the first issue area that we looked at was civilian targeting. And as a reminder, our prediction was that if Islamic armed groups are adhering to Islamic humanitarian law, and non-Islamic armed groups are adhering to public or Western international humanitarian law, and I recognize those are big ifs, and I'll get back to that later, then we really wouldn't expect to see much difference when it comes to civilian targeting. And what we did was we looked at some recent analyses of civilian targeting, and just kind of added this variable of Islamic armed group to see what would happen. And specifically, we looked at Jessica Stanton's really terrific book on civilian targeting, and also Heron Joe's book, Compliant Rebels. And what we found was kind of mixed. When Stanton is looking at restraint, whether rebel groups are exercising restraint, there's no effect, which is actually what we predicted. But when it comes to terrorism, our reanalysis of her data suggests that actually Islamic armed groups are more likely to engage in terrorism than non-Islamic armed groups. And I think that does fit with some conventional wisdom. But turning to Joe's analysis, again, adding this variable of Islamic armed groups, Joe's dependent variable is a little bit different. She's looking at the number of civilian fatalities, and we find that Islamic armed groups are actually killing significantly fewer people than non-Islamic armed groups. So how do we make sense of these findings? Well, I mean, because you have these groups that are just as likely to exercise restraint, but more likely to exercise terrorism and killing fewer people. But one interpretation is that, taken together, there really is not a clear difference between the Islamic and the non-Islamic armed groups when you look at this range of dependent variables. Another might be that, because terrorist attacks maybe kill fewer people, that might be a way to reconcile these findings. But I think that actually the takeaway is a little bit different, which is that we weren't trying to challenge Stanton or Joe's analysis here. And their argument, I'm going to sort of put them under a big umbrella, is basically that these groups need to gain support from various audiences, sometimes domestic audiences, sometimes international audiences, depending on the group. And their own arguments and their analyses are very robust to the inclusion of the variable that we're adding of Islamic armed groups. And so my takeaway here is that ultimately Islamic armed groups may be beholden to the same political, military, strategic constraints as non-Islamic armed groups. So I want to move on next to child soldiering. And here, again, just to remind you from the legal analysis, when you compare the two legal codes, what you might expect is that Islamic armed groups are going to be more likely to violate public international humanitarian law because the age of adulthood is lower under Islamic law as compared to public international humanitarian law. So here we would expect a difference, but we don't find one. So we're using papers by Baber and Blattman, and also Lasley and Thine. And so we would expect to see that Islamic armed groups are more likely to use child soldiers because their definition of child soldiers is the definition from public international humanitarian law. But that's not what we find. There's actually no effect when you include, the coefficient on Islamic armed groups is not significant. So, what do we do here? How do we make sense of these findings? Well, I mean, I think that in an ideal world, it would be really great to have fine-grained data that's not just binary, is there child soldiering or is there not child soldiering, but data that actually has the age of different participants in armed groups. Because when we're talking about child soldiering here, are we talking about a 7-year-old or are we talking about a 17-year-old? That matters for our argument. I think it's very unlikely, though, that we're going to get that kind of data. But again, I think the more general takeaway here is that including this variable of Islamic armed groups does not in any way upset the apple carts that Baber and Blattman and also Lasley and Thine have constructed. And their argument is pretty similar to the arguments that Joe and Stanton are making in the discussion of civilian targeting. So once again, it seems that Islamic armed groups may simply be constrained by the same political and military forces that non-Islamic armed groups are constrained by. I'm going to start to wrap up and talk about some of the next steps that we're planning on taking in this project. One of the other issue areas that I mentioned in the legal analysis is treatment of the natural environment. The other is treatment of prisoners of war, and it's very difficult to get data on treatment of prisoners of war, and I'm happy to talk about why that is. But there is some data. It turns out Jessica Stanton has data on use of scorched earth tactics. So after sending around the paper, I was playing around a little bit with that data. And here, just to remind you, the expectation according to the legal analysis would be that Islamic armed groups would be less likely to engage in scorched earth tactics than non-Islamic armed groups. And in this very preliminary analysis, this is exactly what we find. However, I don't want to bet too much on these results because they are very preliminary. And so, I mean, I don't know if I have like an election hangover where I'm hesitant to accept results that I like. I'm feeling very burned, so I'm super cautious. But in any case, I do think that some caution is warranted here for two reasons. The first is that there really isn't that much of a literature, at least to my knowledge, on how it is that armed groups treat the natural environment. And so I think we want to give some more thought to what are the appropriate control variables, right? For this analysis, we're just using some pretty standard control variables. And the second point is related, which is that I would hypothesize, and this emerges from some of my earlier work, that secessionist groups are especially unlikely to use scorched earth tactics because they don't want to salt their own earth, and they tend to fight on the territory that they would want to claim as their own independent state. And because we're using Stanton's data here, and she doesn't have a variable for secessionism, that variable is not included in this analysis. Another next step that we need to take is to really take on more directly how we're going to deal with groups like the Islamic State and Boko Haram, extremist groups. The problem here, of course, is coming up with an ex-ante measure of extremism, because a lot of times there's a sense that, well, how do you know an extremist group? Because they're using extremist methods. And if we're trying to explain behavior, then we can't just call them extremism at the get-go. Now, there is a new working paper by Renata Joyce and Paige Fortna that does try to identify extremist goals, and they find that groups that have extremist goals are especially likely to use terrorism. And I very much like this approach of matching aims and means, but I have some hesitations about how it is that they are coding extremist goals. So that's something we want to look into. But with that said, the next issue that we'd like to deal with and would very much like feedback on is kind of what the role of law is here. So a few times I've said, if Islamic armed groups are complying with Islamic humanitarian law, and if non-Islamic armed groups are complying with public international humanitarian law, then ... But I think we need to say more about the extent to which these different groups are really bound by, or maybe even informed by, or informed of these different bodies of law. You could certainly make the case that law doesn't matter for the behavior of either group. I actually think that increasingly it does, and that these groups are increasingly informed of these different bodies of law, but it's always very hard to show, to demonstrate the effect of law on behavior. So let me end. I promised around 25 minutes, and I think I've hit that mark, with the question, which is, does Islamic humanitarian law bind Islamic armed groups? And I think our answer is, it's a little muddy, but we're not so sure that it does. And I will stop there. Thank you.
Thanks so much, Tanisha. We'll proceed now to the Q&A portion of the talk. As I mentioned in chat, please put your questions in Q&A on Zoom. And as per CSAC's tradition, we always give our pre- and postdoctoral fellows a chance to ask the first couple questions. And so I won't go strictly in the order in which they were entered, but start instead with Melissa Carlson. She says, interesting presentation, thank you. I have several questions. First, you motivate your project by saying that most civil wars currently occur in Muslim-majority countries, many of which are in the Middle East. However, many members of Islamic armed groups fighting in these wars, thinking of ISIS, are foreign fighters that herald from more Western cultures. Second, in my own research, I find that, at least in the Syrian context, Islamic extremist groups are often organizationally different from their more moderate counterparts in the sense that they have religious training, their leadership includes an institutionalized religious leader or shura council, and they use a religious court to punish soldier defection. I wonder if you could speak to how the structure of religious groups may impact groups' adherence to humanitarian law generally.
I'm taking notes so that I can have all these questions later on. So first, thank you for these questions. And I think in some ways, my answer is I think the answer to both those questions is related, which is that if you have a lot of foreign fighters, then you do need to socialize them into your organization. And the kinds of organizational structures that you're talking about are very useful for that kind of socialization. And it seems to me entirely plausible that a lot of these extremists, so the argument that you're making and the research that you're doing sounds to me exactly right when it comes to what we think of as these more extremist Islamic armed groups like Islamic State and Boko Haram, where they do really rely on a lot of religious training, for example. So I don't at all object to what you're saying. I think that, well, I mean, please send me a paper if you have one that kind of has a way of distinguishing extremist from non-extremist armed groups. But that, as I noted, as sort of one of the struggles of this paper is that when you talk about Islamic humanitarian law and Islamic armed groups, everybody immediately goes to groups like Islamic State and Boko Haram, when in fact there are lots of other Islamic armed groups as well.
Thanks. The next question is from Lindsay Hundley, another CSAC postdoctoral fellow. She says, thanks for sharing this fantastic research with us. You raised this in the next steps section, but I'm wondering whether you could speak more about whether the Islamic armed groups adopt the more mainstream interpretations of Islamic humanitarian law versus more extremist interpretations based on what you have already seen, based on what you have seen and what you have already done on the rhetorical appeals.
Okay. So again, just writing it down and trying not to mute myself so I don't forget to unmute myself, which is what happened before. So Islamic versus mainstream on rhetorical appeals, or extreme versus mainstream on Islamic on rhetorical appeals. So yeah, in other work, I've made the argument that some of what we would call these extreme groups, like Islamic State, have a really different, this is going to sound a little attenuated, but I promise I'm going to get there. They have a really different demeanor toward thinking about sovereignty than some of the more moderate groups, which is to say that the more moderate groups accept the existing state system, and oftentimes they want to be able to join the existing state system as their own independent state, whereas groups like the Islamic State are really rejecting the Westphalian, the idea of what we talk about or think about as the Westphalian state system. And you see that reflected in these documents by these different groups, and I think also reflected in this sense of what the boundaries of their aims might be, and therefore how compatible their own aims and means might be, not just with Islamic humanitarian law, but with public international humanitarian law as well.
Thanks. So now we go to the main queue, and I do note that a couple of people have entered questions in chat. It's easier to manage if you enter them in the Q&A section. So the next question is from Alan Weiner, and he says, great to see you, Tanisha, and to hear about this really interesting work. Here's a lawyer's sources question. Who created the 2004 Amman Statement? Does it reflect input from different sects, strands of Islam? How do we assess how authoritatively we should treat it?
Okay, so I'm not going to have Alan, good to see you. Thanks for coming. Who created the 2004 Amman Statement? Okay, so my understanding of the 2004 Amman Statement, and I would want to double check with Amelia, who I said is really she's the expert on Islamic law, is that it really was composed of kind of a diversity of Islamic scholars from different schools and sects and strands of Islam, so not just one. And that, so it's not the case that you have scholars from the Islamic State as part of the Amman message or part of the creators of the Amman message, partly because they're trying to respond to groups like the Islamic State. In terms of how authoritatively we should treat it, I think that, this is in some ways the challenge with Islamic law in general. There's no Pope, there's no ICRC, there isn't necessarily one centralized source of authority. But the Amman message is unusual because it had so many parties that were signatories to it, that were participating in it. And it really is, I think, viewed as this consensus statement for that reason, and has authority by virtue of its relative breadth.
Thanks. The next question is from Scott Sagan. He says, on the finding regarding number of civilian casualties from Joe, UCDP, could it be that the lack of discussion of collateral damage versus direct targeting of civilians in Islamic law constrains them more than the Western law, which permits collateral damage as long as it is not disproportionate to the military advantage of destroying a legitimate target? This suggests that the principle of proportionality may be more permissive than constraining on behavior.
So I want to think about this for a moment. So I think that, yes, that's possible. And it's certainly plausible and worth looking into more. As I mentioned earlier, Islamic law, there isn't as much in Islamic law on humanitarian law. It's not as developed as public international humanitarian law. And so you don't necessarily have these long debates about the principle of proportionality. My read of it is that there's more about the principle of distinction and kind of who counts in these different categories than about the principle of proportionality. But yes, I mean, I think that's plausible and worth looking into. So thanks for that comment, Scott.
Great. Next question is from Liana Reyes. Thank you, fantastic presentation. Will you look into the specific armed groups to determine the type of Islamic law they align with? Do you believe this might condition the relationship between Islamic groups and international humanitarian law?
Hi, Liana. A lot of familiar faces on this call. So we did actually do this in, we sort of took some preliminary steps here where we coded the sects of the different Islamic groups, so Sunni, Shia, Salafi, and we didn't find that there was a difference when it came to the different issue areas that we were talking about of civilian targeting and child soldiering. We haven't looked yet at the natural environment.
Great. The next question is from Nazreen Badawi, and folks just keep on entering questions in the Q&A as they occur to you. I have a question regarding how you assess whether a legal system binds a certain group. From the presentation, I gathered that the assumption was that if they don't differ from other groups in their behavior, or if Islamic law does not clearly directly impact their behavior, then this casts doubt on to what extent the legal regime is binding. Doesn't that methodology disregard the issue of the normative value of the law, even when upheld? If we look at IHL, for example, violations of the law do not indicate lack of a binding character, but simply transgression. Why do we think of Islamic law differently?
Okay. Harold, can you please tell me what the person's name is who asked the question again?
Sure. Nazreen Badawi.
Nasreen, thank you. Okay. So I think that I want to kind of separate this into a couple of issues. One is that there's a sort of from a legal perspective, does the law bind? And we're kind of not pronouncing on that. And when we say bound, maybe more properly, we mean to say, are these groups complying with Islamic humanitarian law or public international humanitarian law? And so we're not making a pronouncement on the normative value of either legal code. Now, how do we know if a legal system binds a group, or I would put it, how do we know if these groups are complying with these different legal systems? And I think that's the question I was alluding to, is at the end, as being really challenging. So we can do these kinds of correlational analyses, where are these groups behaving in the way that the legal code would predict that they should behave if they were abiding by that legal code. But it could be the case that even if they are, they're not behaving that way because of the legal code. I think that one way that we really, and here I'm going to go a little bit beyond your question, is one way that we can see the effect of these different legal codes is in the ways in which is in these kind of rhetorical commitments, and also what information we can gather about how informed these groups themselves are about these different codes. And my sense, again, just from reading this trove of documents, is that a lot of Islamic armed groups are actually decently well informed about Islamic humanitarian law, and increasingly, because of groups like Geneva Call and even ICRC, groups are increasingly informed also about public humanitarian law. And these NGOs that are committed to and working in the IHL space, not only are they really trying to train armed groups in international humanitarian law in interesting and creative ways, but they're increasingly trying to learn more about Islamic humanitarian law themselves, so that they can kind of leverage these overlaps between public and Islamic humanitarian law, and increase training in that domain too. You're muted, Harold.
Thanks. And if anybody else has questions, please go ahead and add them to the queue. Next question is from Gufran Salman. Hello, thank you for the interesting presentation. I would like to comment that it's important to highlight the fact that Muslims also get their humanitarian law from the Hadith of the Prophet, which is the words of the Prophet quoted by his companions, and that those usually don't need as much interpretation as the Quran. It is very clear that armed groups that practice terrorism don't much care about the resources.
So I take that as more of a comment, and I think that the analysis in our paper very much agrees with that comment.
Fantastic. I'll give it another minute to see if there are any other questions, but if there is anything else you want to add, Tanisha, I think we have a couple more minutes left.
I guess I would, if I can use this platform to ask the audience some questions, I would be really curious to know if people have suggestions on, if you're trying to predict which groups are going to engage in scorched earth tactics, for example, what are the variables that you would want to include in that analysis? And then again, if, so I wrote down Melissa's information, but I would be really interested to hear if other people have suggestions on how to kind of thread this needle of distinguishing what are conventionally called extremist groups from the more moderate Islamic armed groups, because I think that's another real challenge that we're facing in this paper.
No, I think that's an excellent point. We have another question, but if anybody wants to answer Tanisha's question she just posed right now, just post it in either chat or Q&A, either one, because we'll keep a record. So next person, anonymous attendee, is asking the question, is it problematic to conflate bindingness of law with compliance? Would your analysis be any different if you defined it instead as obligation, thus allowing for better behavior than the absence of law, but short of compliance?
So I hope that we're not confusing or conflating bindingness of law with compliance. So this is what I was trying to get at in response to Nasreen's question, that international law, be it Islamic law or public international law, you could make the argument that it binds these different groups. In fact, most, Alan Weiner, who's on the call also, and I have sort of gone back and forth on this in terms of the ways in which public international humanitarian law bind armed groups who aren't signatories to international humanitarian law. So I think bindingness is different from compliance, and I don't mean to conflate them at all.
Okay, and that the anonymous attendee is in fact Tanya Putnam, another longtime person known to CSAC, former fellow and affiliate. So we have another question from Alan Weiner. He's tagging on to a previous question. He says, I do think it's right to distinguish between whether law is binding and whether the parties to whom it is addressed comply. On the question of whether it is binding, or more precisely, who is bound by it, what will be interesting to know is who is subject to Islamic law, which gets at the issue of who is authorized to wage war under Islamic law. That is, of course, an issue in Christian just war theory, as well as modern customary international law.
Right. So, I mean, I think that's a fair question, Alan. And, I'll be frank and say that we're not really addressing jus ad bellum, or the Islamic version of jus ad bellum, so much as we're focusing on jus in bello. But my sense of this again is that, and there's more, I think, written in Islamic Islamic law on jus ad bellum than jus in bello. But my sense is that all Muslims are supposed to be bound by Islamic law, and it's not really supposed to. There's not that much variation in terms of the breadth of the bindingness.
Thanks, Tanisha. And just a suggestion on the extremism question, I believe there's a literature actually on measuring extremism in populism that might have some interesting things to say. As I recall, it has something to do with, violations of sort of constitutional willingness to violate constitutional norms. I mean, this is obviously for domestic politics, so maybe not applicable, but there might be a discussion there at least of what distinguishes ordinary populism from extremist and populism that might carry over into some just way of measuring extremism.
Okay, that's great. Thank you. We're talking about populism in my class next week. So
great. And I'll try to look. I think I have a couple citations in a journal article to that literature. Melissa Carlson has a couple comments. She says, and then there's another comment from Liana Reyes. So first, Melissa, one of our Middle East Initiative postdoctoral scholars. First, to garner a better sense of authoritative sources of Islamic humanitarian law, you may want to look at agreements registered with the Organization of Islamic Cooperation, or the Arab League. And to answer your question, in addition to the organizational characteristics I mentioned, you may also want to look at groups' published code of conduct, which can reveal the extent to which different interpretations of Sharia are institutionalizing group behavior.
Yeah, I mean, we have looked at these groups' published code of conduct. So these are the documents that I was talking about, and we haven't necessarily been able to find them for all groups, which is why I don't want to pretend like there's no statistical analysis, no content analysis of those documents, because I don't feel like we have a solid, a sample with the kind of contours that we would want in order to justify doing a content analysis. But reading through all these documents, that's why we're seeing, that is where we see these different interpretations of Sharia. I feel like we did look at the OIC and the Arab League, but we'll look again. Thank you for that suggestion.
Thanks, Tanisha. There's another comment from Liana Reyes, and she suggests if extremism is similar to being an outlier, then you could design a measure that would place the group on a continuum, and she also later says range, where the middle is what the Imam has stated, and the extremes are on the outskirts. So minority schools are on the end of the continuum or range.
Okay. Liana, I might follow up with you later on that, because it sounds like there's maybe a visual attached to that comment that would be helpful to see. Thank you.
Great, fantastic. Okay, well, we're almost out of time, but I think we could probably squeeze one more question in if we get one more. Well, if not, please feel free to follow up directly with Professor Fazal. Thank you so much, Tanisha, for a fantastic presentation and a great conversation. And look forward to seeing more work that you've done in this vein coming out very soon, I'm sure. And yes, I know you have a lot of friends on the call, but oh, two more questions came in.
Okay.
Even as I was thanking you. People haven't figured out Washington rules, which is supposed to put your hand up even before you figure out what the question is. So Lindsay Hundley starts by saying, this is more of a comment instead of a question, but I am wondering whether you can disentangle which groups being captured in are being captured in non-Islamic groups. Are there groups in this base category that we're expecting to adhere to public humanitarian law versus those that we might expect not to adhere to public humanitarian law? This might help us interpret whether the competing findings you have, depending on which DV you use.
Yes. Again, just writing down comments because I know that the chat will disappear. Okay. So yes, so Lindsay, you're exactly right that there's a lot of heterogeneity in this reference category of non-Islamic groups. And this is kind of what I was trying to get at when I was talking about the robustness of the findings that, Joe and Stanton and also Baber and Blattman and Lasley and Thine come up with, because they're interested, especially Joe and Stanton are interested in international humanitarian law and compliance with international humanitarian law. And so they're coming up with predictors of which of these groups will comply with international humanitarian law. And they're not just looking for correlations. I mean, they are doing that, but they are explicitly engaging with the legal aspects of the question. And so they find, so there is some evidence in their work, also in my work, the evidence goes back and forth. There's a little bit of debate in the literature that secessionists under certain conditions are more likely to comply with international humanitarian law, again, because they want to convey the impression that if they were to be let into the international community, they would be good and capable members of that international community. And when we look at Islamic secessionists, for example, then we kind of find that they behave similarly to non-Islamic secessionists. So this is the point I'm making, that the political constraints that these groups are facing may override any particular differences than you might expect from these different legal codes.
Great. And then what I think will make the last question for real is from Katie Robinson, and she asks, how do your findings fit in with the existing literature on how ideology affects the behavior of non-state armed groups? Do you think that groups with other types of ideologies, or e.g. communist organizations, would interpret international humanitarian law differently?
That is really interesting. I want to think about this. So if we're thinking about in Nepal, for example, do these groups address or see international humanitarian law differently? This is sometimes a little bit tricky because some of these groups are they have this ideological cast to them, but then they also might have political aims. They're not necessarily just looking to take over the state. Sometimes they're looking to create their own state. And so you have these two forces happening at the same time. There's also, there aren't a ton of communist groups, but it's maybe worth looking. I mean, you've got in El Salvador, but they don't constitute, certainly not a plurality of the groups in these different data sets, but I'll take another look. Thank you for that comment.
Great question. And it also just occurred to me mentioning this, that if you're looking at sort of communist groups, it's interesting to think about whether groups adhere to international humanitarian law or Islamic humanitarian law in the case of the groups you're looking at. To what extent is civil society participating in sort of educating them? Because I know, for example, the case of Colombia with the FARC and the ELN, there's extensive efforts by civil society going back to the 1990s to convince the FARC to adhere to international humanitarian law on child soldiering, on use of mine fields in civilian areas, and so on and so forth. And so that there must be some interesting variation there to where some of these older groups, like the Moro Islamic Liberation Front that you cited in your presentation, they've been around for a while, versus sort of very new groups or maybe very extreme groups. Just a thought. Anyway, thank you everyone for joining us. It's fantastic to have Professor Tanisha Fazal share her most recent work with us, and we look forward to seeing more of it in the future. And it's great to welcome you back to CSAC.
Oh, thanks. Thanks everybody for taking the time today. I really appreciate it.